Steve, go ahead and call him.
First one's an inmate, the Alcus Agerton.
Okay.
I was waiting for you.
No, it's my problem, because everything's on me.
It would be if the inmate was there. Samuel Allen. Come on up.
Governor Tim Gibbs for Mr. Allen. This is 23 CF 1080. Judge, Mr. Allen is present approaching. Judge, we'd like to enter a plea of not guilty on this charge. Leave this set for pretrial August 28th.
And he's charged with,
He's charged with possession of controlled substance and possession of paraphernalia.
all right, you want to set for when?
He should already be scheduled for pretrial August 28th.
Okay, August 28th. Thank you.
Judge.
Get with your attorney, okay? Get ready for your case.
Okay. Go ahead and set up an appointment, okay?
Gregory Butterworth.
These arraignment docket,
Yes, sir.
would the state attorneys tell them what they're charged with? Because I don't seem to have my docket for some reason.
This is Gregory Butterworth.
Yep.
Okay, he's charged with possession of controlled substance, methamphetamines. Information was filed on June 15, 2023. The state's offer would be to plead to a lesser included offense of paraphernalia for a withhold of adjudication and court costs, if he takes it today.
So plead to one count of possession of paraphernalia, a
Yes, Your Honor.
misdemeanor?
It's misdemeanor, yes. For a withhold and court costs.
Okay, you can take care of your case today. They're going to lower the charges down from a felony to a misdemeanor. And if you want to enter a no contest plea, I'm going to withhold adjudication. That means you don't have any legal conviction, okay? And standard court costs. Do you want to do that? All right, would you please, Mr. Butterworth, would you please raise your right hand to be sworn? You swear the test... That's the other right hand. isn't it?
Other right hand, yeah.
And you swear the testimony you give for us, court's truth, so help you God? You swear to tell the truth?
Yes.
Okay, you put your hand. All right, you want to enter a no contest plea to possession of paraphernalia, a misdemeanor, lesser included offense. You understand that?
Yes.
Is anyone forcing you or threatening you to enter this plea? All right. Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you aware of the rights you're waiving by entering this plea? Your right to a trial, right to have an attorney, right to remain silent, right to... Okay. The court finds the plea is freely and voluntarily entered. Court accepts it. Withholds adjudication of guilt, sentences you to pay standard court costs. Okay? No probation, no jail time.
Thank you.
All right, thank you.
Thank you.
I'll give you, Mr. Butterworth, listen to me. Listen to me. I'm going to give you 120 days to pay it if the court costs, otherwise they go to judgment. You can get with the clerk's office, they'll tell you how much,
How many
okay?
days, 20 days?
Pardon?
What did you say?
I'll give you 120 days to pay.
Okay.
If you don't pay it, go to a judgment. But you can go down to the clerk's office and find out how much you owe. Okay?
When I find out how much the court costs are.
$270. I'll give you 120 days to pay that to the clerk, okay? Otherwise, it'll go to a judgment. Okay? Thank you.
Thank you.
James Cardell.
Is it Cardell or Cardo?
Cardell, C-A-R-D-E-L-L.
James Cardell.
He's charged with possession of controlled substance, information filed June 15th. The state's offer would be for plea as charged, adjudicate, but only court costs. So I'm asking for a plea to the felony for just the payment of court costs. He has a prior record. He has prior felonies, at least 3.
All All right. Mr. Cordell, the state's offering you, if you want to enter a no contest plea to possession of controlled substance, I'll judge you guilty and make you pay court costs, and that's it. No probation, no jail time, no nothing like that. Want to do that? Would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God. Okay, can you speak into that microphone so we can get it
I
recorded?
said, yes, sir.
Okay. You want to enter a no contest plea to a third-degree felony possession of a controlled substance?
Yes, sir.
Are you aware of the rights you're waiving by entering this no contest plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here
No,
today? Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty. Pay standard court costs is how much?
$615.
$615. I'll give you 120 days to pay it, or it goes to collections, okay?
Yes, sir.
That's it. Thank you, sir. You got to be fingerprinted, I think, doesn't he? No. He was,
Sir, Mr. Cardell? Yeah. Come up here, I'm gonna get your fingerprints in a moment. Just hang out with me for a minute. Yeah, we've got our inmates available, so I'm gonna pick up. This Agerton? All right. I'm gonna stand here at this lectern, face the judge, sir. Mr. Agerton.
Your Honor, Tim Gibbs on behalf of Alcus Agerton Jr. This is 23 CF 1184. Judge, we have an agreement if I may approach.
Mr. Agerton, would you please raise your right hand and be sworn? You swear the testimony you give for this court the truth, so help you God?
Yes, sir.
Okay. This is 23 CF 1184, State of Florida versus Alcus Agerton Jr., and you want to enter a no contest plea to loitering and prowling, a second-degree misdemeanor, and possession of paraphernalia, a first-degree misdemeanor, and the state's going to dismiss the felony charge.
Yes, Your Honor.
You want to do that, Mr. Agerton?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you happy with the work your attorney, Mr. Gibbs, has done for you?
Likely glad, sir. Yes, sir.
Pardon?
Yes, sir.
Okay. Court finds the plea is freely and voluntarily entered. Court accepts it. On counts 2 and 3, you're sentenced to time served in the county jail, $100 cost of prosecution, $220 court costs, $150 PD fee, due within 180 days of release or to collections adjudicated on the misdemeanors. Guilty.
Thank you, Judge.
Should get out today, stay out of trouble. Next.
Mr. Armstrong?
Your Honor, Tim Gibbs on behalf of Rashad Armstrong. Make sure what?
Is this Rashad?
Yes, Your Honor. Rashad
Okay.
Armstrong. I believe this was a transfer up from the south end for a new law violation, if I'm not mistaken. I just somehow missed him on my docket, Judge. Should be 23 CF 1291, if I'm not mistaken. Judge, we'd like to plead not guilty and leave this set for pretrial.
August 28th.
Thank you, Judge.
Thank you, sir.
Mr. Banks?
Your Honor, Tim Gibbs on behalf of James Henry Banks. Come right here. Your Honor, he's here on 23 CF 1081, 23 CF 1083. Your Honor, we'd like to enter a not guilty plea, leave this set for pretrial August 28th.
What's he charged with?
Judge, he's got essentially armed burglary in each case, Judge. Allegations involving that he got into some vehicles and stole some firearms.
Okay, August 28th, you said?
Yes, Your Honor.
Not guilty?
pretrial.
Okay, thank you.
Thank you, Judge. That's just your official charging document, so we'll talk more about that. I'm going to talk to you, okay?
Ms. Burgess? Come on out.
Let's purchase.
All right, this is, what's your name, please?
Ms. Burgess?
What's your first name?
Kayla?
Kayla Burgess? What's Ms. Burgess charged with?
She's charged with possession of controlled substance and possession of paraphernalia. I wanted to mention, Your Honor, to the court, I received a letter from a Center for Drug Addiction, and I believe she's been accepted. My offer would have been, so I would offer bars to bed to the rehab center if she's willing to plead today. I'm not sure if Ms. Burgess is aware of this letter that I received.
Why don't I appoint the public defender, and so she can really understand what she's doing or what's happening? And,
Judge, yeah.
Yes.
Could we leave her on status for maybe July 27th?
Oh, don't do that. I can definitely,
Do you want to take that offer to do a bars to bed inpatient program?
I mean, yeah, but what about the holding center as a county?
I don't know anything about that. That's one thing.
Well, what we'll do is we'll set her for July 6th so you can check into all that.
That could work, Judge.
Okay.
Thank you, Judge.
All right.
So we'll just come back next Thursday, okay?
Okay.
Not
that's
guilty.
fine with me.
July 6th.
Jamel Coleman.
Janelle Coleman?
Be out of custody.
Judge, I'm seeing no response.
Janelle?
Jamel, Jamel.
Jamel, we'll just call him at the end, see if he shows up.
Thank you, Judge.
Diana Craig.
Your Honor, Tim Gibbs for Miss Diana Craig. This is 23 CF 1185. If I may have just one moment. I understand that you're not going to trial on this. You're giving up your rights to go to a trial and make the state prove the charges against you. Do you understand that? That's what you want to do, if I can grab it. You have any questions about what this means? If you would please put today's date, June 29th.
I know, that's the center. Okay.
So on my end, thank you very much.
Ms. Craig, would you please raise your right hand and be sworn? You swear the testimony you give before this court is true, so help you God.
Yes.
Your Honor, if I may approach.
This is 23 CF 1185, State versus Diana Michelle Craig. Ms. Craig, you want to enter a no contest plea to the charge of driving license suspended or revoked, a second-degree misdemeanor, and possession of paraphernalia, a first-degree misdemeanor, and the state is going to dismiss the felony.
That's correct, Your Honor.
You want to enter a no contest plea to that?
Yes, sir.
And did you read and sign this plea and sentencing agreement form?
Yes, sir.
You understand the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No.
You under the influence of any alcohol or drugs that would prevent you from knowing what you're doing here today?
No, sir.
You happy with the work Mr. Gibbs has done for you on your case? She have a prior record?
I think she has a slight prior record with some misdemeanors.
No. I can show you the score sheet.
Is there a bit of a prior record?
It's got a F1,
Okay.
trafficking in amphetamine.
All right, adjudicated on both counts.
But only on misdemeanors. So still, as far as this is concerned, you wouldn't make a big problem.
All right, your sentence, you're adjudicated guilty both counts. Since the time served, county jail concurrent on counts 2 and 3, $100 cost of prosecution, $250 court costs, $150 PD fee, due within 180 days or to collections.
Thank you, Judge.
Okay?
And that's your copy. That's just what you were charged with.
Javon Davis.
right. You're Javon Davis?
Yes, sir.
Okay. What's Mr. Davis charged with?
He's charged, Your Honor, with grand theft of a motor vehicle. The offer that I have in the file is for either plead to a petty theft for a withhold of adjudication, 1 year of probation, 50 hours community service hours, and anti-theft class. So it would be a plea to a misdemeanor with.
And you want to do that? You're charged with grand theft auto. They're going to drop the charge down to petty theft. If you want to enter a plea, I'll withhold adjudication, which means you don't have a conviction, 1 year probation, and take the anti-theft course and $50 court costs.
Take it to trial.
Take it to trial. I'll appoint the public defender to represent you, set it for August 28th. Okay.
Thank you, Your Honor.
Mr. Gibbs, that offer was good only for today, so we can rediscuss the new offer. Yes.
Thank you.
All right, your name, please, sir?
Robert Faulkner.
Robert Faulkner. What's Mr. Faulkner charged with?
I'm sorry, Judge, what was the last name?
Robert Faulkner?
Faulkner? Oh. It's a fugitive from justice, Your Honor. He needs to be held until, I guess, I don't know if he's filed a waiver or not.
You mean for extradition or something?
The waiver, yes.
Your Honor, if I may, as a friend of the court, Mr. Faulkner, did you sign a waiver of extradition for him?
I did, yeah. On the first appearance, when I
Is
got here.
that what state?
Ohio.
Ohio?
Yes, sir.
Well, they've been contacted to come get you?
Still here.
I'll appoint the public defender to,
As the state attorney's office would be responsible for that when I was with the state attorney's office.
yeah, I was going to, well, let me appoint the public defender to,
Responsible for what?
To contact the receiving state, confirm that they want, it's actually done administratively
Well, it
over in
used to be done maybe
Escambia.
at your time. We don't do it now.
No,
I'm
no,
not
it
gonna-
wouldn't be, it's done administratively.
Okay.
look,
above your-
It's ultimately up to the governor's office.
yeah, that's what I was going to say.
It's ultimately up to the governor's office. Now that he's signed a waiver of extradition, he's essentially waived his time. The time frame that's normally required, that up to 90 days before he can just simply be released.
Right.
So it's up to the governor's office and it's up to Ohio. If Ohio decides they don't want to come get them, they need to confirm that with the state of Florida.
Isn't it 30 days for some type of bond or something?
So if he's still here within 30 days and there hasn't been an extension, he's eligible simply for release.
Yeah,
There's no bond conditions. It's
Okay.
simply release.
I've been here for 5 weeks yesterday. I don't know if it's business days or not, but
It's days.
5 weeks.
He's signed his waiver of extradition, Judge. I would simply,
the second day.
if we've been appointed, I'd just orally move to release him.
He was arrested May 24th.
Arrested May 24th, been in jail all that time, and they have not come to get him, no contact from Ohio or anything?
Well, Your Honor, we don't have a motion now for anything like this. It's an arraignment, I believe. So at the very least, it should be pushed to
Arraignment for
next
what?
week.
It's not an arraignment because it's not a criminal charge.
I'll bring him back at the end and give the state a chance to see if there's anything they want to check out. You want that?
Your Honor, he needs to be in jail until the other state comes picks him up.
Right, I mean,
I
I
mean, if
understand.
you
He's been
want to
in-
release him, it's
he's
on
been in
the
30
court
he's been in,
prerogative.
What's,
Ohio may be surrounding states only on his warrant. There's no way for me to find that out, but that's sometimes an issue. I used to work on
Yeah.
these when I was with the state.
they always have different rules. That's what's so hard about it.
Yeah, our state on a lot of things, at least over folks that were wanted out of Santa Rosa, we have it as surrounding states only. I was once tasked with increasing or making it where, anywhere in the U.S.
Fugitive from justice from what? What was the charge?
Judge, I don't know. On the extradition, the only issue is, was it actually a judge that signed the warrant? And is he actually the man named in the warrant? But I don't know Do we have anything that
The only
tells
thing that
us what the charge was?
The only thing I have in benchmark is an arrest report from a local agency that just says they saw him, they found him, they see that he has a warrant. That's all I have.
Not a teletype attached to it?
There's not a teletype attached to the arrest report, no.
We don't usually get those.
They usually are for these cases, is my
Oh,
experience.
you do? Okay, we never got them in Santa Rosa.
So he's not facing any charges in Florida, correct?
Correct.
And he was arrested back in May, something you told me?
Like I said,
May 24th, I think he said the 24th.
May 24th.
He's been in this jail since May 24th. There was a Taylor County hold that's been released. He's been released on bond in that. Otherwise, Judge, the jail's information is that he has a Franklin County, Ohio charges for trafficking in drugs, but that's the only thing holding him in our jail. There are no local charges.
But Taylor County, Florida has got charges on him?
He's been released on bond on that case, so he's eligible for release on that charge anyway. The jail is not currently holding him on that charge.
There's some kind of song, Indiana Wants Me or something, when I was I guess you're lucky you're not in Indiana.
Can we set it for next week, Your Honor, and I have a chance to contact Ohio?
Had 5 weeks.
Huh?
He's out on bond on a charge out of Taylor County. He's going to have to answer in Taylor County. So, what you facing in Taylor County? What charge there?
So I had a resisting arrest without violence. It was from January 1st of this year. Went out. And then I had missed the court date. I had been down here working in Florida for the last year in Gainesville, building the UF dorm addition. And I called to reschedule the court date, and I guess I called on the day that it was supposed to happen instead of what I thought was the day before.
So, he's out on bond from a case in Taylor County, Florida. Ohio won't come get him.
Judge, usually, Mr. Gibbs is right, it's actually between the governor's offices, but at least when I was in Santa Rosa, Mr. Parker, the chief assistant over in Santa Rosa, and his legal assistant coordinated any issues with, do we need to ask to extend the 60 days to 90 days, things along those lines. So they tend to monitor that. I'm assuming Mr. Anker's secretary would be doing that. I don't know if they'll talk with me, but it might be possible to make a quick phone call.
Bring him back at the end of the day, and then the state can check with whoever they feel like they want to check with. Okay? We'll bring you back at the end of the day.
Okay, thank you, Your Honor.
Judge.
Michael Folsom?
Yes.
Judge, I've just been told that they assigned it to the individual state attorney. That there was a policy change since I was over there. And Lisa's saying that it falls on you guys now, which...
And that could have changed since I left, but
All
that
right.
was the policy.
Your name's Mr. Pulp Fiction is what?
Michael Folsom.
Folsom?
Yes, sir.
Okay. What's
He's charged, Your Honor, with driving while license canceled, suspended, or revoked, and the offer would be for plea to lesser included misdemeanor, driving while license suspended, for adjudication of guilt, court costs, and show proof of driver's license or eligibility within 90 days.
You want to do that?
Yes, sir.
Would you raise your right hand and be sworn? You swear the testimony you give for this court is true, so help you God?
Yes, sir.
Miss Leona, can I have a case number on that?
4623 CF 1130.
All right, Mr. Polson, you want to enter a plea to a lesser included offense misdemeanor driving license suspended. You want to enter that plea?
Yes,
No
sir.
contest plea to that? You waive the rights you're waiving by entering that plea?
Yes, sir.
Anyone force you, threaten you to enter this plea?
No, sir.
You under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, adjudicates you guilty, sentence you to standard court costs. Show proof of license within 90 days or eligibility. And that was it, correct?
Yes, sir.
No jail time, no probation.
No.
Okay, thank you, sir.
Thank you, sir.
Brianna Green.
All right, what's Miss Green charged with?
She's charged with possession of controlled substance and possession of paraphernalia. The offer would be to dismiss the felony plea as charged to the misdemeanor, withhold of adjudication and court costs.
You want to do that?
Yes, sir.
Miss Green, and a case number on that, please?
23 CF 1137.
Ms. Green, would you raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God?
Yes, sir.
You want to enter a no contest plea to the charge of possession of paraphernalia misdemeanor,
Yes, sir.
and that's 23 CF 1137. Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
Yes, sir.
You under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, withholds adjudication of guilt, and assesses you standard court costs. Pay that, okay?
Thank you.
Thank you.
Ms. Griffin.
Your Honor, Tim Gibbs on behalf of Kaylee Griffin. This is 23 CF 1103. Judge, we have reached an agreement, if I may approach.
This is 23 CF 1103, State versus Kaylee Griffin. Ms. Griffin, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
Yes, sir.
You want to enter a no contest plea to the charge of battery on a detainee, a third-degree felony, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, sentences you to 13.8 months Department of Corrections. Credit for time served concurrent with 23 CF 298 already sentenced. $100 cost of prosecution, $767 court costs, $150 PD fee, 2 collections. Adjudicated guilty. Thank you.
Daniel Horn.
Do I have a score sheet on this one, Ms.
I believe this did prepare one. I've seen it. That's
Griffin?
reach of that amount for Ms. Griffin.
Daniel Horn, sir.
Judge, this is Daniel Horn.
Okay.
Judge, I'm going to enter a plea of not guilty on his behalf, request 15 days from you for your motions and being trial by jury.
What's he charged with?
Judge, I don't know, well, I do. He's charged with possession, no, excuse me, I'm sorry. That's the wrong-
It's armed burglary, a possession of firearm by convicted felon, and ground
No,
theft.
no, This is Daniel
Horn?
Horn.
Right.
You're charged falsely impersonating, you've got falsely impersonating an officer on the information. The statute's the same for all of them. He actually is alleged to have falsely impersonated a firefighter.
Oh, that's the firefight, okay.
Well, so I'm a little confused. First of all, we got the right person up here.
We do. This is Mr. Horn. We've met before. He's come into
Mr.
my
Horn.
office.
He's charged with impersonating a
Yes, sir. The
fighter.
state's filed an information alleging that he did falsely assume or pretend to be a firefighter and had taken upon himself to act as such. It's
that
section
third-
843.08.
Third-degree felony?
Yes, sir, it's an F3L2.
And so no burglary, armed burglary?
No, Judge, I was reading that wrong information. That was, it was my mistake.
You feel better about that, don't you, Mr. Horn?
Yes, Your Honor.
Because those are very serious charges. Well, is there an offer for him?
Yes, it's for an adjudication of guilt, 2 years probation, court cost, and a mental health evaluation and treatment, or mental health court as condition of probation.
Judge, we're going to have to reject that at this time, place him on the trial docket.
August 28th.
Thank you, Judge.
See your attorney, maybe you can work it out, okay?
Yes, Your Honor.
Thank you.
Yeah, just schedule another appointment. I'm not going to be available for you on that.
All right, this is,
Alicia Hutto.
Morning, Judge. This is Alicia Hutto. Judge, with regard to Ms. Hutto, I'm going to enter a plea of not guilty on her behalf. Request 14 days.
what's she charged with?
Now, I'm not, it looks like they've handed her a copy of the information. Currently, she's charged with burglary of structure while armed with explosives or dangerous weapon, possession of a firearm, ammunition, or electric weapon by a convicted felon, and grand theft of a firearm. Those are the formal charges.
Not guilty on that one, say August 28th.
Thank you, Judge.
Stacy Rice.
Judge, I don't think we've been appointed on her. Stand over here.
What's her name? Stacy Kageris?
Yes, sir.
What's she charged with?
She's charged with tampering with evidence, possession of drug paraphernalia, and resisting officer without violence. The state's offer would be to please charge count 2 and 3, the misdemeanors, dismiss count 1, withhold of adjudication, court cost, and credit for time served.
What are the misdemeanors?
Both of them misdemeanors.
I mean, what are they charged, what are they?
Oh, what are they? I'm sorry, Your Honor. Possession of drug paraphernalia and resisting without violence.
All right, is it Carisi, is that what we said? Is that your name, ma'am? Kageris?
Yeah, I was here because of failure to appear to a court date. That's all I know about.
Well, you're here on arraignment for a felony and also 2 misdemeanors. The state has offered to drop the charges of the felony, which was what?
It was tampering with evidence.
Tampering, the state's going to drop that charge. If you want to enter a no contest plea, the state's going to drop the tampering with evidence. You'll be pleading to possession of paraphernalia, a misdemeanor, second-degree misdemeanor, and resisting without violence, a first-degree misdemeanor. And I'm going to give you, if you want to do this, time served, no additional jail time, and standard court costs, and withhold adjudication, which means you won't have a conviction. Do you want to do that?
I don't know, I'm confused.
I'll appoint the public defender August 28th. Thank you. She's pleading not guilty. She's pled not guilty on those charges. Next.
Travis Lucero.
I know, look at you.
Ms. Corderos, forgot.
All right. Travis Lucero, correct?
Judge, this is Mr. Lucero. I'll enter plea of not guilty in his behalf.
Charged with what?
We've got an information filed on him, possession of controlled substance more than 20 grams of cannabis, no vehicle registration, no motorcycle authorization on driver's license, and reckless driving. So you've got 1 third-degree level 1 felony, 2 second-degree misdemeanors, and 1 first. They've got it as a first-degree misdemeanor, Judge. If this is his first reckless driving, it's the maximum 90 days county jail. If it's his second one and it's not charged as a second one, then it would be 6 months.
Okay, and you pleaded not guilty?
Yes, sir.
August
Pleading not
28th?
guilty, request jury trial, 15 days for pre-arraignment.
August 28th, thank you.
Thank you, Judge.
Get with your attorney, see if you can get it worked out.
Brandon Kelly.
All right, Brandon Kelly.
Sorry, Judge. Likewise, with Mr. Kelly, Judge, I will let everybody know I filed a bond reduction motion for him today, and my secretary's been instructed to get it set. Enter a plea of not guilty on his behalf, request 15 days for any pre-arraignment motions, and demand trial by jury.
Charged with what?
Oh, I'm sorry, Judge. I don't have a copy of his information.
1 second, Your Honor.
One has not been filed yet. I'll just still enter a plea of not guilty, and I'll monitor it, make sure it gets filed before the end of speedy trial. Otherwise, we've got to pass this arraignment and bring him back.
Yes, Your Honor, can we pass it for next week, please?
Okay, you want to set it for July 6th?
Yes, yes.
Okay, July 6th. Thank you.
They haven't filed the formal charges against him, so they're going to get that filed by the 6th, and they're going to bring it back then. I'll be here with you then.
Thank you.
Carolyn Mendoza.
Hey, Ms. Mendoza. Judge, this is Carolyn Mendoza. I think I may have an information on her. Yes, sir, she's charged with possession of a controlled substance, third-degree felony. It's THC. And that's it. I'll enter a plea of not guilty on her behalf, request 15 days for pre-arraignment motions, and demand trial by jury.
Is there any offer?
Yeah, there was. A plea to lesser included misdemeanor, possession of marijuana less than 20 grams for credit for time served and court costs.
All right. And the offer is they'll reduce it to a misdemeanor marijuana charge, and adjudication will be withheld, so you would not have a formal conviction. You would ask if you've been convicted at this time, and you would say no. All right. Did you say withheld adjudication?
Yes, sir.
And standard court costs.
And then just court costs. Okay, you've got the right to do that, but you'll be fighting it on a felony. Okay, all right. All right, Judge, she's not willing to accept that offer at this time, and so I'll keep the plea of not guilty entered on her behalf. And ma'am, come by my office and we'll go over the. Okay. Just call the office.
Good, thank you, August 28th. Thank you.
Thank you.
Oh, I'm sorry.
Yeah, we handled Mr. Moody this morning.
Venus Grobillard or Robillard? Sorry if I messed that up.
You did better on it than I would have.
I just give it multiple tries all at once.
Your Honor, she is present and approaching. This is my client. We're going to enter a not guilty plea, and
She's charged with what?
she is charged with battery on a law enforcement officer and simple battery.
Any offers?
Yes, Your Honor, I did convey that with her. At this time, she is not willing to
Okay,
accept that.
we'll put her on August 28th then.
Thank you.
Not guilty.
No, you can keep that. Yes.
Ms. Snipes. It's yours. Right here, stand just like you did. Allison Snipes.
Your Honor, if I may have just a brief moment with her. Your Honor, if we could have this case put on Monday, I believe the victim had filed a request to drop
All
charges.
right, what's she charged with?
Your Honor, she's charged with felony battery.
All right, July 3rd. Okay, any problem with that, State?
No, no problem.
Okay, July 3rd, thank you.
Thank you, sir.
Next to be Mr. Sprague. There we go. This is yours. Just stand at that flag. Next to Ms. Rivers and face the judge. Sprague.
Your Honor, I believe he is charged with one count of exploitation of the elderly and fraudulent use of a credit card. We're going to tender a not guilty plea at this time and request 828.
Okay, August 28th, thank you. Not guilty.
That's all I have for a plea document.
All right, let me start in the back. Are you, ma'am, with the blue blouse, are you here on a case? No, gentleman in the green shirt, are you here on a case? Come on up.
This may be our 2 o'clock.
All right, sir, what is your name, please?
Hudson Robinson.
What was it?
Hudson Robinson.
Hudson Robertson?
Good.
Charges dropped, any objection? Okay, thank you. And now we will go to you, ma'am. Are you here for a case? Yes. Pardon? Come on down. All right, what's your name, please, ma'am?
Alicia Johnson.
Ms. Johnson?
She's on our 2 o'clock docket, Your Honor.
Okay, is she, who's she?
I'm Assistant Attorney.
Mr. Gibbs, you represent her?
The one that you're telling me about? Okay. all
She
right.
and Mr. Ryan Johnson.
Judge, this lays on the 2 o'clock docket. This was Mr. Gibbs' case. He transferred it over to me. She was determined to be incompetent. She remains incompetent. It's been over 2 years. It's based on developmental disability.
Intellectual disability,
So she's entitled to release.
Or you mean charges dropped or something? Is
No,
that what
Your
you're
Honor. We understand that that's the defense's position. However, Your Honor, when originally Ms. Johnson was found to be incompetent to proceed, that was based on a psychological evaluation that was done by a psychologist, by a doctor. And there were specific findings that had to be made by statute in order for the court to review that and then find her incompetent to proceed. Subsequent to that, she was remanded for incompetency training. And now we have a memo basically from the coordinator, the court liaison, saying she remains incompetent to proceed and that she is not likely to be restored. Well, granted, that's his opinion, but Your Honor, we believe that in order for the court to make that factual finding that she's non-restorable, that the court should require no less than what the court originally found her incompetent to proceed, which is a statutory evaluation that is done by a licensed clinical psychologist that then actually meets the criteria so the court can make that finding. Additionally, Your Honor, if the court just releases her now without actually relying on a report, just relying on the memo that says she's incompetent to proceed and not likely to be restored, then the state still has an option to civilly commit her. However, we also require a report that's done by statute, an evaluation, in order to even petition for that commitment. There would be no way for the state to obtain that report because there's no way to require Ms. Johnson to participate. So in essence, the court is then turning her out into the community. She's potentially a danger to that community based on the charges, and there's no way then for the state to even pursue the civil commitment. So what we're asking the court to do is to order a psychological evaluation to be done in accordance with the statute that makes the findings that are required, basically to see if she can survive on her own, to see if she's a danger to others. There's some specific findings that need to be made, that then be presented to the court, and then the court on a hearing can make that determination based on the appropriate reports. We don't believe this is prejudicial to the defendant, Your Honor, because she is not incarcerated. So to require her to participate in that particular evaluation is not going to be prejudicial to her. It safeguards society, and then it gives the court the statutory information that it needs, not just a finding by a supervisor, basically. Now, granted, I'm not saying he doesn't know his job, but he's not the licensed psychologist that we need to make that finding for the courts. The court can rely on that as competent evidence. So we are opposing the dismissal today. We're just asking that the court order that evaluation be done.
Judge, unfortunately, that determination of what needs to be required is one that the legislature has to make. And thus far, the legislature has made the determination that if it's more than 2 years and they are not restored to competency, and there is no evidence that she has been restored to competency, then the charges have to be dismissed with leave for the state to refile should she ever become competent. In terms of seeking an involuntary commitment or something of that nature, Judge, they can go through the same process for guardianship. They can go through the process for Baker Act. They can go through the process. I don't think there's any drug or alcohol use alleged here, but if there were a Marchman Act, there's simply not a provision in the statute for the state to delay the proceedings and seek that relief. Nor has the state moved to do so, and this issue has been heard twice since I've been here. This one and then a previous before a senior judge, and then this lady's been placed on the docket for today, and no motion's been filed by the state to require her to submit to an evaluation so that the court would have it in time for that 2-year time frame to make a decision on it. So I think the relief that the state's seeking first needs to go to the legislature in terms of an actual change in the law. And I'll be frank with you, Mr. Gibbs is more expert on this area than I am. Or to seek whatever, in the appropriate type of case, well, she wouldn't be now because she's out of jail, but they could file whatever petitions for guardianship or anything along those lines that they seek to request. But they're going to have to meet those statutory burdens, most of which I think are clear and convincing evidence.
So it's been 2 years, right?
Yes.
And
Your Honor, I'm sorry, but our concern is the information to the court that she remains unrestorable is not being made by the licensed clinical psychologist. It's basically just a court liaison that's providing that information. It's a form of a memo. It's not a report. It doesn't meet the statutory requirements for the court to have that evidence to make that finding. And this is a significant step. So all we're asking for is that that report be prepared after an appropriate evaluation.
Your Honor, if I may, her restorability is not relevant to the fact that it has been beyond 2 years since she was found by this court to be not competent to proceed due to intellectual disability, which is under section 916.30, I believe 302 of the Florida statutes that deals with intellectual disability. It creates a substantial due process right that after 2 years, if she is not competent to proceed, has not been found by this court, regardless of what information the court has, if she has not been found competent by this court, she has a substantive due process right to dismissal without prejudice of these charges, because with intellectual disability, the courts find that it's far less likely that she would be restored after that 2-year period if she's got a continued incompetence. incompetency. In addition, once a defendant is found incompetent to stand trial, there is a presumption of continuing incompetency. Thus, that makes another evaluation irrelevant to determine if she's not restorable because we are past that 2-year period. That quote comes from State v. Smith, which is 982 Southern 2nd, 756 on page 758. It's a Florida 4th DCA case from 2008.
Judge, in the case of, say, schizophrenic, you can give them Seroquel. In the case of most other mental disorders, you can give them Thorazine. You can tamp down the symptoms, all right, and you may reach a point where somebody can be restored. There is nothing that is going to give this lady a higher IQ. She is developmentally disabled. She's been determined to be that. They tried to train her competently, or have her competency training. It's been 2 years. It's been past the statutory cutoff, and she's still not competent. The only relief under the statute as written today would have been if prior to that 2 years, she had been determined to be competent. But the 2 years has passed. It's a hard deck. It is what it is. The only other relief to the state is if later, it's determined that she is competent and the state can proceed. Let's say if she got arrested on something new later on, the state could, and there was a competency evaluation for that, or I guess the state could ask for a competency evaluation on that because, she's previously been determined to be incompetent, so she wouldn't be competent to enter a plea or go to trial until she'd been determined to be competent. Then they could ask for that. But the statute says 2 years. There's no interpretation involved. There's no question involved. Their relief is if somehow or another they can show that she's competent later, they can refile. But the charges as they are now have to be dismissed under the statute.
That dismissal also tolls statute of limitations. So effectively, there is no statute of limitations. If at any time during Ms. Johnson's life, later on down the road, if the state has information that deems that she's competent and the court can find that she's competent to proceed, the state can bring back those charges. In addition, Mr. Williams is exactly right that the 2 years is a hard line rule. Now, the state's options are that they could try to civilly commit her under 393.11. However, that statute requires actually a committee that we're still trying to figure out how that committee is supposed to be created that has at least one licensed physician on it. Looking at 393.11, which is the civil commitment statute for intellectual disability, that is a separate thing where she could be compelled to undergo evaluation, but it is a civil commitment.
Well, what else, Ms. Basso?
Just, Your Honor, again, the court is being asked to make a finding based on basically just argument, not any evidence of non-restorability.
Statute of limitation is not a finding. A statute of limitation is a time frame.
But basically, they're saying that she is non-restorable, but we don't have that in the form of a report.
But that has nothing to do with the time frame, does it? A time frame is a time frame.
You're correct.
Dismissed.
Restorability is, yes, thank you,
With the
Judge.
leave to file charges again if she's found to be competent.
And Judge, restorability is a question from before you get to the 2 years. If somebody determines
Already
she's
ruled
not
you
restorable-
want to snatch defeat from the jaws of victory?
No, Judge, I'm not. I'm just...
Your Honor, we have another one exactly like this coming up, except this person really is a danger. But if you want to go ahead and do that one, it's the same arguments.
Who?
Mr. Ryan Johnson?
Where is he?
Judge, I don't know that Mr. Johnson is... Oh,
He's here.
He's here. Your Honor, Mr. Johnson's case, his charges are exposing himself and masturbating to minors near a bus stop where the children could see him. He's done that at least 2 separate occasions. We are asking the court to give us the opportunity to get his mental health evaluated so that we have that report so that we can then seek civil commitment. And if without that, we have absolutely no way of getting him to participate. We want to keep society safe.
Judge, again, the statute says what it says. It's a hardline rule. Their relief, if there's going to be relief on this issue, is going to have to come from the legislature.
Well, same deal, 2 years. They
Same
had
deal.
2 years. And they
He's
had
been on conditional release for 4 years now, Judge, just like Ms. Shalitra Johnson was.
conditional relief. Mr. Johnson is Johnson, right?
Johnson.
Been on conditional relief for 4 years. Nothing's been done regarding the competency, correct?
He's not been restored to competency.
Not been restored to competency. The 2-year statute of limitation has run, correct?
It's a 2-year bright line rule, Judge, that says after 2 years, the charges must be dismissed without prejudice.
And the state, if he's restored to competency, he can refile.
Yes, sir.
Absolutely.
It's the problem we run
Dismissed.
into. Okay. It's they don't notify us in time to get those reports done.
I know, well, the statute of limitations is the statute of limitations.
And I will say on the record that I do share that same concern from APD as well as DCF, that these status reports come in fairly quickly when they try to set them for hearing.
Thank you.
But
Thank you, Judge.
thank you, Judge.
Now, we have, who do we have back there? A lady with the green blouse? Gentleman with the yellow T-shirt, yellow shirt? Come on up. All right, sir, your name, please?
Jamel Coleman.
Jamel Coleman? Okay.
Sorry for being late, sir.
You're here, you're right, you're on time, you're here when I called
Yes,
you.
sir.
Mr. Coleman is charged with possession of a firearm, ammunition, or electric weapon by convicted felon, driving while license counsel suspended or revoked, misdemeanor. The offer would be to dismiss count 1 and plead to count 2, adjudication of guilt, credit for time served, and court costs.
And what is,
I represent Mr. Coleman.
oh, you do?
Yes, Your
Well,
Honor.
he's got an offer to plead to a misdemeanor for time served and court costs.
Indeed.
So, I'm your attorney. You can take that offer.
He wants time to talk about the case a little bit.
So, Judge, if we just do a not guilty plea today and set this for pretrial August 28th.
The offer is revoked, though, because this is for today.
All right, well, hang on a second. He's looking at a felony. They're going to reduce it down to a misdemeanor, adjudicated, time served, walk out of here, just pay court costs.
Repeat the offer, I'm sorry. I did not hear the whole thing. I had been distracted. I'm sorry.
It was for dismiss count 1, the felony, plead to count 2, the misdemeanor, driving while license suspended, for an adjudication of guilt, credit for time served, and court costs.
If we could take that today. I'm sorry, Ms. Leone. If we could take that today, he certainly wants to.
Okay, sure.
It's, what was Mr. Coleman's first name?
Jamel,
Jamel.
Jamel.
Would you raise your right hand, please, to be sworn? You swear the testimony you give for this court's truth, so help you God?
Yes, sir.
You want to enter a no contest plea to a misdemeanor driving license suspended, is that correct?
Yes, sir.
Are you aware of the right, you can put your hand down. You aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
You under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court finds the plea is freely and voluntarily entered. The court accepts it. Judge you guilty, sentence you to credit for time served, pay standard court costs. He has 120 days to do it, or it goes to collections. Okay?
For the record, that count 1 is dismissed, right?
Count one
Yes.
is dismissed.
Thank you.
Mr. Coleman, I'm going to get your fingerprints.
Yes, sir.
Appreciate it. All I have left is Jennifer Albro.
Yes, that is also mine.
Well, and then Faulkner will bring back.
Yes, we can bring Mr. Faulkner back. I have it. Here, Mr. Coleman. This is just your copy. Your Honor, Tim Gibbs on behalf of Jennifer Michelle Albro. This is 21 CF 2514. Judge, she's going to want to enter a plea to the bench on this case. This is a violation of probation, Your Honor.
All right, you're Jennifer Albro. Would you please raise your right hand to be sworn? Swear the
Yes, sir.
testimony you give for this court's the truth, so help you God?
Yes, sir.
So, Judge, she does have, so the violation, based on a couple new misdemeanor cases, one involving an affray, one I believe also involving a paraphernalia. The score sheet we received from the state indicates that she scores presumptive minimum of 19.05 months in the Department of Corrections. As I'm sure the court would be aware, she does have quite a history. That's what leads her to score so much on these kinds of charges. It's mostly drug history, Judge. I know she's been to DOC before on drug-related charges. She actually has an acceptance to the Teen Challenge program in Pensacola for an inpatient or residential treatment. That program is about 12 months long. We have that letter. The state has provided a copy of that letter. This is actually your copy from Discovery. If the court would like to see that letter for her acceptance, to understand where she is, that's essentially what we're asking, is for a discretionary resentencing for Ms. Alber because it is a violation of probation or violation of community control. She scores under 60 points. We're asking the court to essentially utilize its discretion in order to let her go to that treatment program, placing her back on community control and otherwise for probation up to the 5-year maximum, however long the court would deem appropriate for her to be able to enter that program. I know she's been in other programs here before, but that's what we're asking for today, Judge.
I haven't taken her plea yet.
Okay.
I was going to wait for that.
Oh, sorry.
Ms. Albro, did you read and sign this plea and sentencing form?
Yes, sir.
You understand the rights you're waiving by entering this admission to violation of probation?
Yes, sir.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the admission is freely and voluntarily entered. Court accepts it.
Yes, sir.
And so you want that program, and Ms. Leon, what do you say?
Okay, I'm going to say first address the letter of acceptance that I've shared with the defense. It's not a letter of acceptance, and that was going to be my argument. It doesn't even state the name of the defendant. It's a general letter informing of the type of program that they have. This letter was sent to my office by defendant's mother. So no, there is no acceptance letter. First. Second, defense is quite incorrect to say that the court has discretion to put her in a program like that, because the statute requires that, and it's here in the score sheet also, the defendant is amenable to the services of a post-adjudicatory treatment-based drug court program, not just any program. It's the drug court program like the one that Judge Ward presides over. So she has had several violations of probation. This is not the first one. This is not the first time she's been on probation. She's been on community control. Not only this, she picked up 2 different charges at 2 different times. She was arrested for possession of paraphernalia in February 2023. She's out on bond again. She's given that chance. And then she gets into a fight, into an affray with another person on April 4, 2023. She has violated probation multiple times. This violation is material because, of course, she committed another offense. Violated also technically because she did not submit to a substance abuse evaluation. The score sheet offered the court some guidelines to ensure that defendants face the same type of sentence based on the same criteria and the circumstances. In her case, she scores 53.4 points, which amount to a minimum of 19.05. So for the court to go below the 19.05, it has to find 2 findings. That one, there is competent evidence that the defense had presented for the court to even consider that, and then whether the court should. Now, the first prong is missing because there's no evidence that warrants a downward departure, and the court should not, because this defendant has been afforded several chances, and she failed every time. So I'm asking for, at the very least, 19 months of DOC.
Your Honor, I'm sorry. When I referred to the letter earlier, that was, Ms. Leone is correct, that was simply a general letter. My office did receive a letter from Corby Rushing, who is the admissions coordinator, indicating that Ms. Albro has been accepted. I thought I had filed that in reciprocal discovery. I had not. I do have a copy, a digital copy that I can certainly file with the court, indicating that Ms. Albro has been accepted. I'm happy to provide that to the court, for the court to see that. In addition, regarding downward departure, the list of statutory departure reasons, it's not exclusive to that list. So departures based on reasons not delineated in 921.006 may be permissible. This is based on Randall, State v. Randall, which is 746 Southern 2nd 550 at 552. It's a Florida 5th DCA case from 1999. There's also a 1998 third DCA case, State v. Toro, as well as State v. Tyrell, which is a 2002 case. So the court does have its ability to find other reasons for departure beyond what are simply delineated in the statute. In this situation, Ms. Albrecht does have an opportunity to go to a treatment-based program. It's not a post-adjudicatory drug court treatment program, but there is that option there. And besides, because this is a purely sentencing issue in the sense that this is a violation of a sentencing order, the court does have the discretion to modify. My understanding is that the court does have the discretion to modify the sentence to whatever the court believes is appropriate, of course, keeping the guidelines in mind.
How long has she been in jail on this VOP?
She's been in jail, Judge, most recently, her arrest, I believe it's about 3 months. She's been
Since
in.
April,
Since April, so almost 3 months.
April 3rd.
Just shy of 3 months,
How many
Judge.
times is she alleged to have violated probation?
Can I call probation, Your Honor, to the stand? Get some testimony?
Just answer that question.
Okay.
This probation, once, I know she's had other cases, again, I do know she has a longer history. Again, most of it revolves around drugs.
Mr. Mary?
This is the second violation. She was originally placed on probation for 24 months. She violated with a misdemeanor battery. That was just on regular probation. As a result of that offense, they placed her on 1-year community control with me. Then she was at another local motel and got into it with somebody else.
There's something about she failed to take registered for a substance abuse
I did do
evaluation.
There is that allegation, Judge, yes.
I did it.
She has been referred to, part of her conditions of supervision was to go and get a substance abuse evaluation, completing recommended treatment. I don't think she completed any,
I was at Patterson. I switched to Patterson that week.
but you haven't completed any.
No, I
She
still
hasn't-
had,
I know she hasn't completed, but
I did do it.
Your Honor, to be quite candid with the court, I've followed this girl all around Crestview from every hotel in Crestview on community control. I've tried to drag her out of every hotel in Crestview and told her to get right. And she hasn't. I'm not saying she can or can't. She just hasn't. And I've asked her, did she need help? I was concerned for her safety with the person she was with because I saw bruises on her. I asked her, could I call anyone? Did she have anywhere to go? I offered up shelter house, everything. She'll tell you I did. And I really, really tried to help her. And then she got arrested.
And if the court prefers, Your Honor, then there's something else. I went to listen to jail calls. I have copies of the jail calls that I've shared with defense. She's not that remorseful as she wants to appear here on the camera.
Okay, hang on one second.
Let me just make sure I've got that certificate.
All right, the court, I guess she was already adjudicated guilty, I guess. 19.05 months DOC, credit for time served.
Thank you.
Thank you. Revoke and terminate probation.
Hughes or Faulkner next? You just pick the closest one to the door.
Whoever's closest to the door.
Who's closest to the door? Come on. Let your face, Judge Folsom. This is Matthew Hughes from this morning's document.
All right, Mr. Hughes, refresh my memory on Mr. Hughes. I've had so many cases I've forgotten.
It was for a VOP arraignment, right?
Judge, we had
Yeah.
Mr. Hughes earlier this morning. Hang on a second, because I got notes.
We was gonna see how much time I had on my 11/29.
Oh, yes, yes. He asked for a jail offer and he was gonna check the credit that he had, right, Mr. Williams?
How much do you think you have?
I know I was 4.5, and I wanna say at least 6 months to the good.
At least 6 months in
I think
jail?
so.
Is it all here in this jail? Because I can check the jail side too.
Yes, ma'am, I've done 10 days in Alabama. That was
10
all.
days?
Yes, ma'am.
And then I've got 9/20 to 12/3.
9/20 to 12/3.
So that's about 2.5 months.
Okay, so we should have a roughly 75, and then when was the arrest date for this?
6/8.
And then I should have
6/8.
had 4.5 to the good a long time ago. Because they left me in here.
Same charge, or is this?
Yes, ma'am.
This looks
it's the same
like
charge.
resisting with violence. Yeah, I'm showing,
Is it, or did you have an original, you were being held in another county?
Just for,
Okay, so what I was waiting on was to see if I got anything
but I
back.
think they told me that I wouldn't get that accounted for. It was just going to be.
No, not unless we have a letter of incarceration from the other county. So on this one, it looks like we're talking 75 plus roughly, I'm going to say maybe 20, probably around 95, 100 days.
So is that 4.5 that I had?
I'm going to say, Your Honor, if I may, when he was originally sentenced to probation, he was sentenced to, was it Heaton?
Yes, ma'am.
He was sentenced to Heaton, and I believe he was never screened for Heaton. So he sat in jail for 4 months. The only person he knew to call were his parents, which there was an injunction. So when he called his parents, that got him in more trouble. So he just sat there on dead time until we reached out to the court, and he never got out of jail to go to Keaton. We reached out to the court. They let him out, let him do outpatient substance abuse. But Ms. Rivers at the time was his public defender. Oh, she was a state attorney, I'm sorry. And she agreed to give him credit for that basically dead time if he ever had a VOP.
I will give him that credit.
this is 21 CF
It's 4
2763,
months
right?
that he sat.
Yeah, no, I
This
have
is,
no
this is
issues with
21
that.
CF
So what's he
276.
pleading to?
Mr. William,
Judge, he's got over a
he's
year.
admitted,
Yeah.
revoke and terminate.
He's got over a year.
Can you announce the?
All right, the case number is 21 CF 2763. This is a violation of probation, so it would be him admitting to the probation, or to the violation of probation. And
His name is, again?
His name is Matthew J. Hughes.
Yes, sir.
And it looks like he's served, they say in over a year here.
Over a year,
Mr.
Judge.
He served over a year
Just in
already.
this jail.
So he's got the credit? I mean, I
He's
don't
already,
know.
he's already served a year is what they said.
So my offer was 1129, right?
So with that, yeah, go ahead and plead to the 11.
They'll figure out.
Are we good with that probation?
That means I'd get out today.
Yes.
Unless you got something else.
I could just sentence him to time served.
Judge, that would be the easiest.
That's fine, Your Honor.
That way we don't have,
So let's just-
they might be sitting in jail for 10, 15 days waiting with the holiday and everything. I mean,
That's okay, I'm fine, Your Honor.
all right,
Go ahead.
Mr. Hughes, would you raise your right hand and be sworn? You swear the testimony you give for this court is true, so help you God?
Yes, sir.
You want to admit that you violated probation? You can put your hand down. You do?
You need to answer the court, but if what you want is set this offer for time served, the answer is going to be yes.
Yes, time served.
Okay, are you aware of the rights you're waiving by entering this plea, this admission? Your right to a hearing, a right to a trial, you're waiving all that, you understand that?
I don't really understand much of it, if you know what I mean. I don't want to hurt myself by saying anything, but
It's what we talked about when I came out to see you yesterday. You've got a right to fight this. You've got a right to make them prove it. The burden of proof is only preponderance of the evidence, though, and you don't have a right to a jury trial on it. It'd be a hearing in front of the judge, and it'd be much less than the level of proof that you're using.
Let me just tell you this.
yes, sir.
I'm going to let you out today. I'm sentencing you to time served if you want to admit you violated probation.
Oh, yes, sir, I did admit, I did.
If you don't want to admit it, you don't have to admit it, but you're going to go back to that jail and wait till we get around to trying you.
No, I did.
And that might be a couple of months.
No, sir, I did violate, sir.
Mr. Williams wants to explain all this legal stuff to you for the record, but I'm trying to make it just crystal clear. I'm going to let you out of jail today.
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, sentences you to time served.
Thank you,
All
Judge.
right?
and outstanding monies to collection.
Outstanding to collections, adjudicated guilty. Revoke and terminate. Mr. Williams, sometimes you just, you know Mr. Menendez down in Fort Walton Beach?
No, sir, I don't.
Sometimes one or perhaps one or two too many words.
Mr. Medina.
Medina, one or too many words.
Yeah, you're good, man.
Sometimes you just,
Judge, I'll tell you about a trial that I had once
No,
with
no.
Pharaoh Kiprios and Ed Zeitlin in
I
front
don't
of
even
Judge
want to
Jones.
hear it.
Let's
We got one more gentleman to take care of.
Yes.
All right, the next one.
May I approach you? That's the score sheet for the gentleman
Come
before.
on out, sir. Your turn, face the judge, please, sir.
We're back on Mr. Faulkner's case. This is the fugitive from justice issue that we had earlier regarding really what the right procedure is supposed to be regarding the fact that he's been in the jail for over 5 months. Your Honor, there really isn't any record as, well, let me check again, because when I checked earlier, according to the clerk, there was no record that he had actually signed his waiver of extradition. I know he says he has. I'm not saying he's a liar. I take him at his word, but we don't have a record that he's actually signed it. It's not in the clerk's, it's not in Benchmark. It's not in the clerk's file. All I see in the court file for Mr. Faulkner at this time is an arrest report from the sheriff's office indicating that they found him for whatever reason, that he had a wanted person out of Franklin County, Ohio, that they had a wanted status. They confirmed they had a hit confirmation. They provide that number, but they don't provide any copy of that hit confirmation, of teletype, and there's not a record of first appearance for Mr. Faulkner in the court file, and as such, there's no record that he's actually signed the waiver of extradition. Without that record, we can't say definitively that he has. Without that record, if he hasn't waived his extradition, it's been more than 30 days. There was never a request within that 30 days to extend the amount of time for him to be extradited, to wait for the governor's warrant. As such, I believe he's entitled to be discharged. The case, of course, stays open, but I believe he's entitled to release.
My notes show that the jail communicated with our office that his waiver, that the note is for May 31st. The waiver was sent over today, and we are waiting to hear back from their transport department. So he did sign a waiver. They sent it out to Ohio or whatever.
So we're waiting to hear from Ohio.
That's the last thing. So I would like to have a chance to talk to the jail and find out. So can we set it for Monday?
I think that's fair.
Yes.
I think that's fair.
Thank you.
I want you to have a chance.
Because that way, if Ohio's going to come get you.
It's a complicated issue, check on it, we'll
Yes,
see,
Your Honor.
we'll look at
I'll
it.
have an answer on Monday.
I think we can, yeah, that's totally fair. Thank you, Judge.
Thank you.
Thank you. All right, y'all had some pretty good scrimmages today, it was enjoyable.
We had fun.
Good thing you're enjoying this, John.
So I guess the next court date is the 3rd, and I'm
That's correct.
sorry about that court date. I mean, I didn't